You are welcome to the webinar. My name is Jesse Heyman, Associate of Koranteng Legal Advisors, and you're welcome to the webinar entitled Intellectual Property on Social Media, Navigating Copyright, Privacy, and Monetization. Before I introduce my special guest, I will give a brief rundown of how things will go. But first, let me begin by the why of it all. Why are we all gathered here today? So, Koranteng Legal Advisors, under the auspices of our managing partner, Koranteng, has put this program together because as a firm, we have always had an eye towards the future, right? There is a famous African proverb which says, if your neighbor's beard is on fire, put some water beside your own, right? And seeing how the global trends concerning intellectual property, content, and all those things are going, it is prudent to arm not only our audience, but ourselves on what to do, what to know about this fast-moving, ever-sprawling sector, right? And so before we begin, massive thanks to our managing partner and all those who helped put this webinar together. Now, a brief overview before we begin. So there will be 3 guests, which I will mention shortly, but prior to the presentation of each guest, I will do a detailed introduction as they all deserve, and then after our final guest, we will go for a Q&A session. And so if you are in the chat, you have any questions, just put them there and our guests will get to it and make sure that your curiosity is sated. All right. So in 1996, Bill Gates wrote an infamous essay called "Content is King." And he begins with the following opening line. He says, "Content is where I expect much of the real money on the internet will be made." Bill Gates goes on to write about how, as the internet grows, becomes more widely used, a new marketplace will emerge there where both individuals, corporations will be able to make money producing content online. 20-something years later, that young man's prophecy came true. Just to have a scope of how right he was, every 60 seconds, every minute, 500 hours of content are uploaded to YouTube. Every 60 seconds, 1.4 million people scroll Facebook. 3.4 million snaps are created. 695,000 Instagram posts are shared. 5,000 TikToks are made. By the time I finish this very sentence, $1.6 million will be spent online, right? This is a market that is huge and sprawling, and there's something for everyone here. There's a lot of opportunity in this new frontier. And the best thing about it is the windows are open to basically everybody, right? If you're here and you're into cars, you will find a car community that can consume whatever you want to sell or say. If you're into books, you find a book community on social media. If you are into porcelain teacups, you will find a porcelain teacup community on social media. It does not discriminate. Literally, everyone stands something to gain from getting more familiar with the laws and mechanisms that comprise the online media space. Lawyers, doctors, bankers, traders, and entrepreneurs, teachers, farmers, executives, accountants, scientists, artists, whoever, right? Whatever you do, there is a niche network on social media that will hear what you're saying, buy what you're selling, or simply if you want to network or not commercialize what you're doing, there's a space there for you. And it's important for you to know these things, even if you don't plan on selling something for commercial purposes. And to that, there is the case study of ChatGPT and various artificial intelligence systems that are mining people's social media posts, Facebook posts, Instagram posts, Twitter posts to train their various algorithms and things like that. And so it is good to know if you have any sort of legal recourse or rights or where you stand as far as the law goes. So there's two tracks we're going to run down today, right? And they will intersect at various points. The first track we run down is the legal track, the rules and do's and don'ts, what are the various entitlements I have with regards to things I create, right? And there is the money track, the second track, how you can leverage these opportunities to earn some income or perhaps gain notoriety, bring attention to you as a brand or to bring attention to you as a product, right? And these two tracks will coalesce and diverge at various points, and that is reflected by the three guests we have with us today, right? So a brief rundown of the guests, but I will do justice and introduce them properly as they're each about to speak. One, we have none other than Mr. Ismail Andani Abdullahi, who is a tech lawyer and partner of Renaissance Law Chambers. For speaker two, we have Mr. Winston Watcher, a tech analyst and content creator. And speaker three, we have digital marketing firm CEO Brand Nerds Ghana Limited, represented none other by CEO Mr. Edwin Della, right? And so let me hand over to our first guest. Right, Mr. Ismail Andani Abdullahi is a private legal practitioner and founding partner at Renaissance Law Chambers, where he heads the firm's law and technology practice. He has a master's degree in law and technology from University of California, Berkeley. He's also part-time lecturer at Lancaster University, Ghana, where he teaches intellectual property and cyber crime. And when I was in Oxford, he was personally my favorite lecturer. I don't think I've ever told him that, but yes, he was my favorite lecturer in school and one of the smartest men I know. So I will hand over to him. Thank you.
Thank you very much, Jesse. I'm touched. Just a quick second to load up my slides. Okay, so are the slides visible?
Yes, please.
All right, so thank you very much, Jesse, for the introduction. And thank you very much to all who have taken their time to join us here. So as Jesse has introduced me, I practice law and technology. And what that simply means is that my specialization is in areas in the field. As far as today's discussions are going to go from the legal point of view, I would like to start by quickly speaking about what I seek to achieve by the time we are done here. So effectively, what I want to do is that by the time we are done, you would be able to appreciate the complexity surrounding social media and the law. And essentially have a desire to take personal action based on what you hear. Of course, this is not a full legal class, and I'm presuming that quite a number of people joining us are not lawyers. So I'll try my best to be as simple as possible, break down things as simple as possible. Now, to achieve this objective, my agenda is a pretty simple one. So I'll start by briefly talking about the social media landscape. And I'll be brief because I suspect my other colleagues on the panel would have more to say about that. And so I want to do that just so we have a certain context in which to look at the legal issues. Then I'll speak also about the legal framework of ICT generally in Ghana, and then zone down to discussing three topical issues that congregate at the intersection of social media and the law. So we'll start off with looking at a few social media statistics based on Ghana. And what I'm going to speak to is based on what is known as the Digital 2023 report, which you can find at datareportal.com. So now this report is essentially an amalgamation of different researches that have been conducted over certain periods. And the time period for this is January 2023. So that's a couple of months ago. So now the first set of highlights I want to show you are the general ones. So Ghana's population, according to them, is 33.8 million. Out of this number, 43.88 million people have a mobile phone or some form of cellular connection. 23 million, that's 68.2% of our population, according to this research, uses the internet. And for our purposes, 6.6 million people in Ghana are active social media users. Okay. Next, highlights internet access. Okay. So in Ghana, according to the statistics we have here, 68.2% of the Ghanaian population use the internet. And this is interesting because you notice from this slide that more people have access to the internet than they have to basic sanitation. So access to basic sanitation is 23.7%, whereas access or use of internet is quite significant at 68.2%. Now, what I'm trying to do here is for us to have a contextual background. And that context is based on the fact that social media is actually a thing in Ghana. So based on the next slide, you notice that okay, right. So based on the next slide, you notice that as I said earlier, 6.6 million social media users. 19.5%, that is when you look at the population vis-a-vis people who use social media. More than 32% of social media users are above 18. Quite interesting. And 28.6% of the population of internet users use social media. Now, an interesting thing here is that the average time spent using social media each day by Ghanaians is 3 hours and 28 minutes. I don't know whether that is true. The average number of social media platforms used each month. So what that means is that for at least for us who use social media, each month we look at 4.7% of at least 4.7 social media platforms. In terms of gender breakdown, you have female to a total is 40.5%. So 40.5% of women use social media. And for males, it is 59.5%. Now, another interesting insight has to do with the reason why people use social media, right? So you notice that the first one, according to the research, as of January 2023, is that they want to keep in touch with friends and family. That's about 49.4%. 41.4% of the of Ghanaians want to read news stories, so that is keeping current. And my personal favorite is the third one, seeing who has been talked about. So the Kokonsa lovers amongst us, we are largely represented here. So you notice that going through these stats, you are developing a certain sense of how social media works in Ghana. And here you see that it's doing justice to the name social, because all the reasons here are essentially social in nature. Okay. Now, the next slide shows us the most used social media platforms. The most used social media platforms. And unsurprisingly, number one is WhatsApp, where a whopping 83.6% of the population of persons aged between 16 to 64 have an account. This is followed by Facebook, Instagram. So WhatsApp is really the, at least as of January 2023, WhatsApp was the highest grossing social media platform in terms of percentage use. Now, the next slide shows us social media in a more directed context. And that has to do with the use of social media for brand research. So this is where the monetization issues come in, right? So you notice that 89.4% of internet users between the ages of 16 and 64 find information in respect of brands on any kind of social media. And 68.3 specifically look for that kind of information on social networks. Okay, so you have your Instagrams, your Twitters, etc. It's now X, sorry. Now, still on the monetary trajectory, the next slide tells us that as of January 2023, Facebook had an advertising audience of 5.65 million people. So what that means is that when you post an ad on Facebook, the likelihood it's likely that it can reach up to 5.65 million people in Ghana. That's quite interesting. That's for Facebook. The next one is Instagram. So with Instagram, the total potential reach is 1.7 million people. So if you post an ad on Instagram, you can reach up to 1.7 million people. Messenger is 885,000. LinkedIn is 2.1 million people. Twitter is 1.15. So with all these platforms, we see that they have a certain level of reach. Okay. Then social media advertising overview. Now, this slide speaks to how much people spend on social media advertising in US dollars, right? And from what I see, the spend on social media advertising in Ghana is 8.84 million cedis. Yeah, it doesn't appear much, but considering the current economy, it's a lot. Then, another interesting aspect is influencer advertising. So what this slide shows us is that the annual spend on influencer advertising in Ghana is 385,000 cedis. So if you aggregate all the influencers, right, and how much they have earned, it's 385,000 cedis. Now, as I indicated earlier, the reason why I bring this up is because of context. When you look at these figures, you begin to see certain trends. One, obviously, is the fact that we are being social in nature. And the thing about being social is that you are going to have a lot of complex relationships. The other thing is that there's a certain value that social media affords. And that value is what transfers into money. Okay. So then the immediate question one would ask is, what has law got to do with any of this? Okay. So remember that we are talking about complex social relationships. And the nature of social media is such that you are dealing with different people in different countries at different times. That has a certain legal impact. So the point is that what social media has to do with law is everything. Because law sort of provides a certain fulcrum around which social media works properly or should work ideally. So the point I'm making here is this. You cannot remove law from social media because the very fact of the existence of social media means that different people from different parts of the world are engaged in very complex social relations. And some of those complex social relations involve money. Okay. And the law has a role to play in all of this. And so I am going to start talking about the legal aspects. And I'll start by talking about the legal landscape of ICT in Ghana. Now, here again, we are still trying to look at context. There appears to be a very prevalent notion in Ghana that we do not have laws that deal with ICT-related matters. And that is actually not true. The question of enforcement is another thing, but we do have some laws that deal with ICT-related matters. And what I like to do is to sort of break those laws down into different groups. Okay, so you have laws that are ICT sector specific, and you have laws that are general in nature. So the ICT specific laws are those ones that were specifically passed to have a focus on ICT related matters. So you have the Electronic Transactions Act, for instance, which deals a lot with online trade. You have the Electronic Communications Act, which has to do mostly with communication service providers. You have the National Communications Authority Act, which establishes the NCA, the National Communications Authority, and guides the kind of work they do. The National Information Technology Act also deals with the National Information Technology Agency, that's NITA. Then quite recently too, we were blessed with what is known as the Cybersecurity Act, which also has provisions that intersect law and ICT. So this category of laws is just specific to ICT related matters. Then we have laws that are general in nature, but which are applicable in the context of ICT. So you have the Data Protection Act, for instance, which deals with privacy and data protection. You have the Copyright Act, which deals with intellectual property relating to artistic, musical, literary, and also audiovisual works. You have the Patent Act, which deals with inventions. Trademarks Act, which also deals with branding and brands. And of course, the Criminal Offences Act, which has provisions that may impact the manner in which we relate to ICT. So the takeaway here is this: there are laws that are Ghanaian, which have an impact on how we behave online generally, and to a large extent in respect of social media. So for those who have had that notion that we don't have laws related to ICT, this is a very good point for you to change that line of thought. So now zooming in into law and social media. Now, what I intend to do with the remaining time I have is just to have an open discussion on certain aspects of law and social media. I'll be limiting myself to 3 things. 1, content, 2, privacy, and 3, jurisdiction. Sadly, there's not enough time to talk about all of the other interesting topics under it, but I felt that based on the kind of things that we are supposed to be discussing today, an introductory discussion of these things would be useful going forward. So law and social media, we are going to be looking at law contextually. And we'll start off with content. So now when you look at social media, content is essentially the link between the consumer, that is the person who is enjoying or benefiting from the content, the creator, the person who manufactures the content, and the social media platform. Okay, so you can say that content is the golden thread that binds all these various groups together. Okay, now content is expressed in different ways. It's expressed through text, so the things we say on social media. It's expressed through images, which can be pictures, which can be drawings. It's expressed through videos. So TikTok is the in thing now. So all of that is content. It can be expressed through sound. Now, the legal categorization of content is what we call intellectual property. And by intellectual property, we are essentially talking about a group of things that are the result of human intellect. So the products of human intellect are what we refer to as intellectual property. And to the extent that content that is created and posted online or that exists online is concerned, it falls as intellectual property because it's, a product of human intellect. Okay, so that's very important to understand. The reason why you'd have a discussion of intellectual property within the context of social media is that content falls under the rubric of intellectual property. Now, what I want to do is that I want to look at content from two different angles. Okay, one from the point of view of monetization, and two from the point of view of moderation. And I want to speak about these two things because they essentially form two of the biggest discussions that legal practitioners who are involved in this space speak about. Okay, so to recap, we are trying to look at the link between between law and social media. And the point I'm making so far is this: to the extent that content is a product of human intellect, then you can consider it as intellectual property. And there are laws by which we can navigate the area. Okay. So now, as I indicated, I'm going to be talking about content from the viewpoint of monetization, and then I'll speak to moderation. Now, okay, I've spoken about this already. Yeah. So now we are told that time is money, and apparently so is content. So as I indicated earlier, intellectual property is that area lawyers will look to in trying to talk about the legal aspects of content. As far as the various strands of intellectual property law are concerned, the two most prominent when it comes to content are the law of copyright and what we call the law of trademarks. So trademarks essentially has to do with branding. And because the topic, I was informed to speak more about copyright, I'll do that. But just to mention that trademarks has to do with branding. Okay. Now, when it comes to copyright, you are essentially talking about that area of the law which deals with artistic and literary works. Okay. So the things that you create that are of an artistic nature, or that are in writing, or that are audiovisual in nature, are things that are protected under the law of copyright. And so that is why content is looked at through the lens of the law of copyright. Now, as far as the law of copyright is concerned, we are usually granted two categories of rights in Ghana, at least. We have what we call economic rights and then moral rights. As far as economic rights are concerned, there are those categories of rights that enable the owner of copyright to benefit financially from. Okay, so a discussion on monetization is necessarily a discussion on economic rights, because one of the economic rights you have is the right to enforce the copying or otherwise of your work. So copyright is the right to make copies. And since you are the owner of the work, you are the one who has the first right to make copies. Now, that right can be monetized in the sense that you can sell it. Okay, you can sell the things you create online. So the kind of content you create is subject to sale. And it can also be licensed. Right? So content is valuable. Content can be traded. You can look at it as an asset, right? Now, you can decide to trade your contents personally or directly, in which case you post something, someone shows an interest in it, and then you can directly deal with the person and say, okay, I want you to pay X amount for this thing that I am giving you. Another way you can see monetization is through the platform. And so here you'd be talking about your YouTubes, your X's, your Facebooks. They have ways in which they can assist you monetize. And so that is essentially through contracting. So you'd notice that for virtually all social media sites, they have contractual provisions that deal with how you can monetize your content. So you notice that here, what the law does as far as content monetization is concerned is that it facilitates it, okay? So what the law says is that your content is valuable. You can deal and you can trade with your content. That is money in your pocket. So that is one aspect of how the law deals with content monetization. The other leg has to do with contract law. And as I indicated earlier, you can monetize through the platform. And that is usually done by way of a contract. So you essentially reach an agreement with the platform you are using, and you determine what you need to do to be able to benefit financially from your content. Okay. So I'm just showing you YouTube's what they call the partner program scheme or program. And this is just so you see how YouTube, for instance, deals with monetization. So you can register, you have to meet certain milestones, and then they will enable you to benefit financially from it. So law, what it does here is to grant you certain rights in terms of your content and the ability to trade that content. Now, the other aspect of content I want to talk about is content moderation. Now, when you talk about moderation, you are essentially talking about vetting what we call user-generated content for compliance. Okay, so as users of social media platforms, we generate content. So that is what is called user-generated content. And this content, questions arise as to whether it should be monitored or not. And the idea behind content moderation is that we want the persons involved want to know whether you are complying with their terms of service or complying with the legal, regime that they work under. And here again, there are two things of interest. One is moderation itself, and two is what is known as intermediary liability. So as far as moderation is concerned, there's this debate as to whether content itself should be monitored in the first place. Okay. And this is usually based on a freedom of expression versus public safety argument. So on one hand, you have people who say, look, we have free speech. Let us say the things we want to say, how we want to say it. And on the other end, we have people who say, no, yes, you have free speech, but there are limits to the kinds of things you say. Okay, so this is one of the raging battles that we see in the space. And another question that arises as a result of this is, by what standards are we going to moderate content? Because in terms of standards, the standards of the US are completely different from that of Ghana. In Ghana, you tell someone that the person is saying nonsense and they'll feel insulted. In the US, elsewhere, they may not feel the same. Okay. And for those who have been watching the social media space quite religiously, you recollect that one of the reasons why Elon Musk decided to purchase Twitter was because of content moderation. And his view was that Twitter should allow, well now X, should allow should be less interested in content moderation. So the things that the old Twitter used to flag it appears that Musk is not really interested in that. Now, as far as the law is concerned here, under the Electronic Transactions Act in Ghana, there are provisions in relation to these kinds of things. So as a social media platform, you're under no obligation to monitor content on your platform, at least based on Ghana law. So if you are a Ghanaian and you have a social media platform that hosts content, you do not have any obligation to monitor content. That's a general principle. The only time you may have an obligation is where perhaps you've been ordered by a competent authority. So maybe a court has ordered you to monitor content, or security services have legitimately told you to do that. Or maybe you have a contractual obligation to do that. But otherwise, as far as the law of Ghana is concerned, social media and actually generally, platforms generally are under no obligation to monitor the content of their users for compliance with law. Then the next leg of this is what is known as intermediary liability. And the question here is whether platforms should be held liable for the contents they host. So that's what's called intermediary liability. Now, globally, there are different models that exist. So you have the strict liability model, which is usually typified by China. And here, any content that is infringing on law, you'll be held liable for it. So that's strict liability. Then you have safe harbor nations. And so with safe harbor, the safe harbor model, what typically happens is that you would only be held liable if you do not meet certain standards, right? And of course, there's a model where there's no liability at all. And Singapore and I believe the US are examples of this. So coming home to Ghana, we are more or less a safe harbor nation. So if you're a social media platform where the laws of Ghana apply to you, you'd only be held liable for the content on your platform if you had knowledge of that content and the fact that that content is infringing on the rights of someone. If you don't remove it expeditiously when a takedown notice has been, you've been notified that it is infringing, and if you don't provide a complaint mechanism for users of your platform to make complaints in terms of unlawful content. Okay, so when these things coincide, then you'll be held liable. Okay, so here again, we see the relationship of the law to social media, right? We see that what the law does in this context is to sort of regulate the relationship between users of platforms and the platforms themselves. And to that, you can also add the creators of content. Okay, so far, what I've been trying to do is to draw a link between content and the law. And I've looked at it from two significant areas. One, content as value in terms of monetization, where I've stated that intellectual property is that aspect of the law which enables us benefits financially. And within the context of social media, we are looking at the law of copyright, because the law of copyright protects the kind of content that we see on social media. And I've also spoken about content in terms of moderation. And what I've stated is that you can look at moderation from two different angles. One has to do with the question whether we should moderate at all, right? And the second has to do with whether platforms should be held liable for content that infringes law. Now, another aspect of the link between social media and law has to do with privacy and data protection. Now, privacy is fundamental. Of course, everybody likes their privacy, or most people like their privacy, let me put it that way. But a lot of people are not shy to post their personal business out there. So privacy is one of those things that is spoken about a lot, okay? And the reason why it is spoken about a lot is because data is essentially the fuel that runs social media platforms. Social media platforms thrive on data, not only for what is known as telemetry, not only for statistical purposes, but because that is what generates revenue for them. So the question that would attract the mind of persons interested in the connection between social media and law has to do with how do you manage privacy on one hand, vis-a-vis the profit-making motive of the platforms on the other hand. And there's this popular saying that if you are not paying for it, you are the target. You understand? So when you're talking about privacy and data protection in the context of social media, we are essentially looking at how platforms treat data. Okay. Now, the treatment of data is based on essentially two things. The first is contract law. So again, we hear contracts. Okay. So as far as contract is concerned, it is essentially an agreement between the service provider, that is the social media platform, and the individual consent. Okay. So in this case, if you are registered with LinkedIn or X, you definitely have to click on their terms of use and agree to their privacy policies. And I'm very confident, I can bet my bottom dollar that I do not know more than 2 people in the world who read these things. And in fact, my bottom dollar is even too much. I should bet my bottom CD that nobody ever reads privacy policies. So what I've shared on this slide, you'd see the privacy policy of LinkedIn and X. So with LinkedIn, they say that they use the information and data that you provide to make recommendations for connections, etc. Okay. And below, that's for X. Our privacy policy describes how we handle the information you provide to us when you use our services. You understand that through your use of the services, you consent. So you see, that's the contract. You consent to the collection and use. So that is what you are contracting X to do with the data that you provide them. Okay. So one of the things that we speak about when it comes to social media and law is privacy, right? And one of the ways we look at it is through the contractual angle. So essentially what is happening is that when you are signing on to these platforms, you are essentially telling them that these are the things that they can use the information you provide them with. Okay. Now, the other way of looking at privacy is through what is called legislation, law. Now, again, people always complain about, what people do with their data. People complain about data mining, okay? Because you are the commodity that is being traded, right? So laws have been put in place by certain countries to regulate some of these things. Perhaps the most popular law is what is known as the GDPR in the EU. But even in Ghana, we have what is known as the Data Protection Act. And what the Data Protection Act does is that it defines the parameters of what data is protected. So you usually have personal data and special personal data, okay? The Data Protection Act requires consent before anybody does anything with the data you provide. Now, you notice that consent, when you log in, when you sign up with a social media platform, is given when you click yes, okay? Then, of course, the Data Protection Act requires registration. And where there are data breaches, you are required as a platform to report the data breach to the person whose data has been breached, as well as the Data Protection Commission. So here again, through the lens of privacy, we see a nexus between social media and law. So one, we have talked about content. Two, we have talked about privacy and data protection. Now, you may be wondering, how then do we navigate all of these things, having regard to the fact that when it comes to social media, most of the platforms are not based in Ghana. So how does Ghana law deal with them, if it deals with them at all? Okay, so you can potentially be in Tikrit in Iraq. You are browsing on, or you are using a social media platform which has a service in maybe Sweden, and you are talking trash about Ghanaian politicians legitimately. You notice that you are dealing with different countries. So which of the laws affect you? And that is what brings me to my final point on this matter, the question of jurisdiction. Now, when we talk of jurisdiction, I'll not enter into an esoteric diatribe on that. But what I'll just say about jurisdiction is that you're essentially talking about the extent of the law. Okay. So in other words, how does the law relate to you as an individual? To what extent can the law be applied to you? Okay. That is the most basic way you may want to look at jurisdiction. In other words, if someone is browsing in Ghana and what he's doing has effects in Sudan, which law applies to that person? So as far as jurisdiction is concerned, there are typically three ways in which a state would have jurisdiction over you. One is presence. So if you are in the country, so if you're in Ghana, Ghanaian law would apply to you, whether you like it or not. The other way is contractually. Again, so you hear the word contract again. Now, you'd notice if you read the terms of service of social media platforms that they always have a dispute resolution clause. In other words, what should happen if you have a problem with them? So you notice on your screen the terms of service from WhatsApp. Okay. And of course, we don't have much time. I'm sure I've spent my time, but I'll just quickly talk about certain salient things. Okay. So you notice at the bottom where they've written governing law, it says that the laws of the state of California govern our terms, as well as any disputes, whether in court or arbitration, which might arise between WhatsApp and you, without regard to conflict of law provision. What this means is that if you actually do use WhatsApp, okay, and you have accepted these terms, when there's a problem between you and WhatsApp and you want to sue, they'll use the law of California to resolve that issue. Okay, so this is how contracts, facilitates jurisdiction. And of course, another way in which jurisdiction can be exercised by a state over you is through a close connection. So for instance, if they can draw a link between you and the country. And so one interesting example would be Kevin Taylor. I'm sure you guys know him. He's a journalist based in the US. He said things which were ostensibly defamatory against a very popular lawyer, that is Nkrumah. And Mr. Nkrumah managed to sue in Ghana and was successful. Okay, because even though, and the court stated that even though Mr. Taylor was not in Ghana, the things he was saying had a close connection to Ghana, right? So the court exercised jurisdiction, right? So what I'm saying in respect of jurisdiction is this. Social media works through the internet, and the internet has no borders. So at every point in time, you are dealing with different laws from different places, okay? And so that is something that you need to have in mind when speaking about social media and the things you want to do on social media. Because at any given point in time, you might be offending one law and another, from one country or another. Okay. So to recap, the three significant things I want you to go home with are: one, the fact that content is money, it is value. Two, that there are serious privacy concerns about content, particularly because of data mining. And three, we are always dealing with several laws at the same time, and there is a huge impact of that. Now, the long and short of all of this is this. The reason why it is important to understand the connection between law and social media is because you need to protect yourself from others. Having a perfunctory knowledge of the law would at least help you to know when people are doing you wrong. And the other thing is that you need to protect you from yourself, because you are also a potential wrongdoer. So that's why understanding law is important. And moving forward, right, you need to appreciate the fact that your dealings online are not as plain and simple as they appear. There are various complicated issues, particularly of a legal nature, that surround the meeting of social media and the law. So you ought to get better educated. You should have the habit of reading the fine prints, and more importantly, consult a lawyer. Thank you very much.
Thank you so much for that very rich presentation. I'm sure we've learned a lot. For a second, I thought I was back in faculty days, and I had a strong urge to bring out a notepad. Thank you so much. That was very enlightening, and frankly, I could have listened to you for 2 or 3 more hours at least. We go on to our next guest, and fun fact, both first guest and second guest, Mr. Winston Watcher, we are all from the one and only school in Ghana, Achimota School. So it's a bit of a reunion here. Yes. I put this conspiracy together, and I didn't tell my boss. Yeah.
Thank you very much.
Yeah. Mo Changa has descended. Yeah. So my second guest, right? He is none other than Mr. Winston Watcher, another one of the smartest guys I know, and he will talk to us about challenges creators face and monetization and all that. And the reason why that was key was because many of you enjoy, whether it's playing the piano, singing, writing, comedy, all that. And for many decades, it was nothing but a pipe dream, right? Your parents would tell you that is not real. Go and get your books, and you just like them. One day you can wind up in the corporate pipeline somewhere. And and but with the rise of many content creators with millions of followers, um, many of whom are completely unheard of by the ordinary Ghanaian. It's seeming less and less of a pipe dream, but many people don't know what to do. They don't know what, like, where to go. They don't know what to click. Right? Yeah, sorry about that. It seems I dropped off. Right. So a second dream, which is by companies, is that they would have access to potentially millions of clients, millions of potential leads without having to pay uh, thousands, hundreds of thousands, sometimes millions of dollars to advertisers, radio stations, TV stations. All right. So before we begin, let me check if Mr. Watcher is. All right. So Miss Winston Watcher is a tech consultant that works with businesses that seek to modernize their services and digitize their operations, data, flow. He is also a recurring panelist, my opinion of experience in content creation in video, both in front and behind the camera, such as video, sound editing, directing, hosting, etc. And is an expert on the ins and outs of software, hardware, and the business of tech industry in general, and um, and was also my senior back in Archie Motor days, and glad to have him here. So Winston, thank you.
Okay. Hi. Thank you, Jesse. That was a very wonderful introduction. I think if I'm ever going to receive an award, I'll call you up to present the award to me. Hello, everyone. Since Jesse has already introduced me, I will just jump right into it. Unfortunately, I don't have a presentation and you can't see my face, but I hope that's perfectly fine. I'm just going to jump straight into it. So, thankfully, Accra Abdullahi or Mr. Abdullahi has done a fantastic job of laying the background, which is about the laws and the ins and outs of the laws concerning social media. Now, the main thing I want us to start off with in my talk is what Mr. Abdullahi mentioned, which is that the internet, or in this case, social media, does not have boundaries. You are creating something that is for the world. It's not only for you, it's not only in your jurisdiction, it's all over the world. So it then creates its own unique forms of challenges. So let's move in. So as a content creator, let's say you decide to become a YouTuber and you decide which niche you want to get into. I will be making this conversation in general, but let's say you're a Ghanaian YouTuber, you want to get into the YouTube space. You decide, you choose. You look at all the things that are going on YouTube in Ghana, and you're like, okay, you know what? For the lack of a better term, the gossip channels seem to be doing very well in terms of viewership numbers consistently. So we have the likes of the Kojo Sheldons and all, and the teacher Kojo. I hope I got his name right. Those guys seem to be making a lot of impact in terms of views. So okay, that's the type of content I would like to make. Now, if you take their content is basically taking information and giving their thoughts on it. So what it's technically called react channels. They are reactionary. You have a video of Kwaju Sheldon reacting to a latest song from a musician or the latest news. Now, the interesting thing about React channels, which is actually a new problem, a new situation that has come up, is that the rules about copyright concerning React channels or people reacting to other people's videos is in a very iffy space. So let's say that you made the video that Kojo Sheldon is going to react to. If you made the video on YouTube, that video falls within the scope of the rules and terms of agreements on YouTube. So to a certain degree, the copyright hold of that video falls under the ordinances that YouTube has set in place, which means that you can file for copyright if you, the creator of the content, are in the right based on YouTube's terms and agreements. Now, recently, there's this popular streamer and YouTuber. So streamers are people who just stream content online, they react, they do all manner of things. His name is XQC. Now, there's a new issue that came up with him because many content creators felt like XQC was not a very good reactor. His reaction channel was not good. And they felt like XQC was not playing according to the fair play rules set by YouTube. Now, the fair play rules YouTube sets are basically a set of rules where YouTube allows other people to create content on other people's content. So that's where the reactors and everything come into play. But the rule states that you should add a significant quantity of new information to whatever it is you are reacting to. Then the question then comes, what is the definition of you should add a new quantity? Like, how do we define the margin of that quantity? Because in the case of XQC's situation, many of the content creators were saying that XQC would just sit on the live stream and you watch the video and you would just be like, okay, that's nice. And they felt like that wasn't transformative. That was not transforming the content in any way, which is what the YouTube Fair Play rules state. But for some reason, his content is still on there. So then you would think you could file a copyright claim, but if YouTube says that he is within his rights or the fair play rights, then you can't file a copyright claim. So these are some of the main challenges that content creators face when they make content online. Let's say Twitter, currently X, for instance. The problem with Twitter is that, which is a problem that all companies, X is a very interesting case study because they seem to not be bothered by the copyright stuff that much. They are one of the only social media platforms that allow anything to be shared on their platform to a certain degree, yes. But when I say anything, I mean within the scope of currently we've seen X Twitter handles or X handles that post full-fledged movies. That should not be allowed. that is a very, very strong breach of the movie creators' copyrights. But it is allowed on Twitter, and Twitter is still facing a lot of problems around that. So the issue for you, a content creator, if you come into the game in terms of protecting your intellectual property, is that you are going to be faced with the challenges of, or you need to understand the rules of engagement per the platform that you are using, because each platform has its own set of rules. And if you are creating this content, you need to understand that because the internet or the content you are creating is on the internet and there are no borders on the internet, anybody can have access to it. Many people can have access to it. But then there are ways to protect yourself. Let's say, for instance, you create a video of YouTube, of the YouTube platform. And let's say it was a day in town and something happens and the video goes viral. You can actually file for copyrights or for lack of a better legal term, you can patent that video so that if anybody uses it on any platform, you can actually file a copyright claim and you can take your money. Now, when it comes to copyright on platforms such as YouTube, Instagram, Facebook, the very, very big corporations, they have it on lock. It's very interesting that we, the laymen, the conversation of copyrights is extremely different from the conversation that these corporations have with these social media platforms, because just if anybody is here and is willing to try, just create a video on YouTube and under the video put any Disney song under it. They will file a copyright claim on that video in less than an hour, and your video will be taken down. These corporations, they work together. They know the laws, they know everything, so they are always on point. But if you come to a content creator in Ghana, let's say, for instance, you make content in Ghana, and now someone somewhere wants to react to it, and you have a problem with it, it becomes slightly more complicated for you to file a copyright claim, because if that person is well within the, like I said, the fair play, fair use rules of YouTube, then you can't file a claim. So like Mr. Abdullah mentioned earlier, if you want to get into some of these or get onto some of these platforms, you should go out of your way to find a lawyer to read the terms and conditions. I have actually read the terms and conditions of some of these platforms. And what you need to keep in mind when you're signing up for these platforms is that whatever they've written in terms and agreements is to their benefit. They are not going to lose out. They pay very expensive lawyers to write and draft out these terms and conditions. They are not going to lose out. So you need to find a way to maximize it. Now, another issue about intellectual property just comes from the other side. Now, for instance, in Australia last year and this year, Canada, they passed a law, and which Mr. Abdullah talks about laws concerning ICT sector. They passed laws that said that tech companies that own or run social media platforms are mandated. This is a very, very interesting case, and I would actually like to hear Mr. Abdullah's take on this, and Jesse and everybody here take on it, that platforms who run social media platforms should pay news reporting sites for featuring the content from these news platform on their search engines or in their For You pages or all one of those things. So basically, you have a situation where, let's say, Daily Graphic is on YouTube, and they post news on YouTube every day. The law is asking YouTube to pay Daily Graphic the same way Daily Graphic pays content creators for all the views and stuff that they get from whatever news article that Daily Graphic puts up. Now, Facebook, Meta, the company Meta that owns Facebook and Instagram, said, if that's the case, we are not going to feature any news channels on any of our platforms in Canada and in Australia. In Australia, they came to a concession. They had an agreement with the Australian authorities and the news outlets, and they came to an agreement. But in Canada, they are like, no, we are not going to allow this. Now, the question then that is posed is that, is news content? And this is a question I'm actually asking Mr. Abdullah. I hope you'll be able to answer me later. That's a very interesting question. And the issue here is that the tech companies are saying that they run the news articles for these news platforms for free, in the sense that they run ads for these news platforms. So, for instance, YouTube will run ads for Daily Graphic for free. It doesn't charge Daily Graphic for any ad stuff that Daily Graphic will do. And they're saying that there's a lot of goodwill stuff that their platforms do for these news agencies. So it's a bit unfair for the news agencies to be asking for compensation. So that's the thing about social media. There's not a lot of ground. I know Mr. Abdullah mentioned that laws are in place. Yes, that's very true. Laws are in place. Like you mentioned, as for their execution, that's a totally different conversation. But the issue is that not many or not enough laws have been put in place to properly govern this. The world still treats these technologies as new things, and we haven't caught up from a legislative point of view. We haven't caught up to where technology is currently. The new conundrum with AI and everything in I believe it's in California. Someone was filing a claim, a copyright claim, saying that anything created by an AI engine should be owned by the AI company, I believe. Another person is also filing a claim saying that if I created art on an AI platform, that should be material that you can copyright. But most of the judges in these cases said no. And it's now becoming a new conundrum. How do we tackle the next phase of the internet, the next phase of social media, which is AI and AI art and all that stuff? Now, you would like to think that we should be talking about technologies that will make it easy to track these things. People have talked about how instead of NFTs being used as some form of cash grab thing for art, why don't we use NFT technology to serve as content ID technology, in a sense that any content on the internet will have a unique identity code tied to whoever posted it first. So you, based on that NFT code, you or that content ID, you have the copyright to that. Well, we're still waiting to see what will happen with that. So intellectual property on the internet, by and large, the big corporations are winning big. They know everything. They know all the nooks and crannies. They know how to deal with any situation that comes up. It is we, the laymen, that are facing challenges. And even in our facing challenges, thankfully, there are certain institutions that have the interests of the people at heart. Like, for instance, when if any of you know the whole Cambridge Analytica situation, the reason why Facebook could be queried or be called to explain and have consequences for their actions is because of the EU's GDPR, which is basically the same thing as Ghana's Data Protection Act, but there's a full-fledged organization for the EU. So the reason why this actually works is because the EU is not just one country. It's a whole group of countries, and they all said, Facebook, what you did was not good. Let's talk about it. They have rules and regulations. If there's a data breach and you don't report it, you pay about 4% of your earnings, your profits that year. There's so many rules, but that's because they have, for lack of a better term, the clout of a massive group of countries. The same goes for America. So if you follow the Cambridge Analytica situation, after Facebook went to face the GDPR in the EU, they then came to face America at Congress, and that was also a very interesting series of events that happened. But at the end of the day, you come to see that the laws concerning social media, the laws concerning technology in general, are largely reactionary at this point, because there are so many new technologies coming. There are so many loopholes in the law that are being taken advantage of by these tech companies. So it's becoming a case-by-case situation. But this should not deter you from joining or creating content on social media. Like Jesse said, there are things that were pipe dreams. I mean, who would have ever thought that you can play video games, just sit at home and play video games, and you would make millions of dollars? It was a totally outlandish thought. It was something many of us were scolded heavily for in our childhood, but now people are making money from doing that. There are people who are making money from just sharing their sentiments on topics. There are people who are making money from, like Jesse said, playing music, creating new covers of music. The opportunities are endless. So regardless of how reactionary the laws governing all of this, or the laws that are trying to govern all of this are, social media is a fantastic opportunity to change your life. Just know how you're going to get into it. Just understand what you're doing. And most importantly, you must have consistency. So I think I will end my talk here. I feel like I've talked a lot. So thank you guys, and I'll be waiting for any questions. Thank you.
Thank you, Winston, for that very illuminating conversation. Just to comment on the point you raised about the news sites in Australia that lobbied for legislation that they should be compensated for these social media sites hosting their articles. There's two directions which you can look at it from that I think are the only ways in which is from the sort of, that is true to a large extent, except in the face of overwhelming power, right? So just imagine you were going to work at Coca-Cola, for example, and they said to work here, you have to wear a